this court is not legislating from the bench. Court is not being an activist. The court is simply following the law as set forth by the legislature and as interpreted by the Nevada Supreme Court. So for those reasons, thank you to our Nevada Judges versus Nevada Department of Motor Vehicles, A25914-630-W.
Good morning, Your Honor. Luke Busby appearing for our Nevada Judges, and Mr. Falcone, I believe, is in the courtroom today.
Mr. Busby and Mr. Falcone, good morning.
Good morning, Your Honor.
Good morning, Your Honor. Adam Honey on behalf of the Department of Motor Vehicles.
Mr. Honey, good morning. Mr. Busby, is your motion?
Thank you, Your Honor. So it's our position that the DMV's refusal to issue a press license plate to Mr. Falcone under Nevada Revised Statutes 423672 is a manifest abuse of discretion. Falcone meets all the requirements under the statute for issuance of a press plate. He's a Nevada resident, editor for our Nevada Judges. He submitted a signed application as well as the required letter and the fee. And the Nevada Supreme Court has affirmed ONJ's status as a press entity on multiple occasions, as described in the briefing through several cases. And ONJ is well known for its extensive judicial coverage, which underscores its press function. The DMV's claim that ONJ is not a newspaper, television, or radio station is simply an anachronism based on the use of those terms as they existed decades ago. The Nevada Supreme Court in Toll v. Wilson clearly held that digital media qualifies as a newspaper under NRS 49275, which is the press shield statute. It rejected that excluding digital formats. It rejected excluding digital formats based on the fact that that's an absurd result, Your Honor. Digital newspaper is a newspaper nonetheless, as is a television station that's on YouTube is a television station. And our Nevada Judges, as I'm sure the court is aware, offers both of these functions, really. It contains a web page which publishes news. He publishes news on Twitter and compiles statistics on the judiciary, as well as keeps the general public up to date on what's happening on, our branch of government, as well as publishing videos of proceedings online. The DMV's insistence on physical print simply repeats the same error that was committed in Toll by the district court in that case, which is basically reading the statute in such a narrow fashion that it produces an absurd result. Now, the denial is arbitrary and capricious, and it violates the legal duty to issue a press plate under the statute where a person qualifies for as much. And writs are specifically designed to address this kind of issue where there's no adequate remedy at law. And the court is entrusted with the power to compel the performance of an act which the law especially enjoins as a duty resulting from the office. And this is exactly what the duty that the statute imposes on the DMV. Falcone can't address this issue through ordinary legal challenges. Writ relief is really his only available remedy. Monetary damages aren't adequate in this case. And further, the DMV's reliance on the plain meaning is misguided, of course, because the Toll Court rejected, what they call the dictionary-based exclusion of digital media from the definitions of the press as they are included in the press shield statute. And the assertion that because the legislature revisited the statute for reasons which seem completely unrelated to the issues in this case in 2013 and 2021 doesn't mean that they intended to exclude digital media. And that's unsupported by any citation to legislative history or anything else. So we request that the court issue a peremptory writ compelling the DMV to issue the press plate under the statute. And with that, I'm glad to answer any questions the court may have.
Thank you, Mr. Busby. Mr. Honey?
Your Honor.
Thank you, Your Honor. In this matter, our Nevada Judges wants to be determined to be a member of the press under NRS 482.3672. The plain meaning interpretation of the statute is clear. There's only one meaning of the statute, is that you have to be a newspaper, television, or radio station. There's no constitutional limitation at issue, such as in toll, where you would need to legislate from the bench essentially and add a meaning or interpret a clear meaning statute by broadening it through the court's interpretation. In the toll case, they were talking about the press shield law, which is essentially a First Amendment issue. The case they cite in order to expand the definitions or to expand that statute, they cited Fourth Amendment cases about thermal imaging. Again, only when a constitutional limitation is at issue is the court then obligated to go beyond the plain meaning of the statute. And that part isn't here. There's no constitutional aspect to this whatsoever. It's clearly this interpretation of the statute. Obviously, it's legislatures' privilege to create statutes and amend statutes as they see fit. The fix to this, if our Nevada judges feels there is one, is a legislative fix, and not to have this court expand a statute that, unlike the press shield statute that was 50 years old, has never been amended, this statute's been amended multiple times. But the legislature's never chosen to amend it to expand it any further. The DMV's job is to interpret statutes as written and to enforce them. They really have no dog in this fight in regards to our Nevada judges, except that they're obligated to interpret the statutes as written. And that's what they've done here. So with that, unless the court has any other questions, I think it's a pretty simple, brief matter on both sides, and we'll submit it on the briefs in addition to my oral argument.
Thank you, Mr. Honey. Mr. Busby, any final rebuttal?
Yes, Your Honor. I'd just like to clarify the issues in the Toll v. Wilson case. That was actually my case. It's been some time, but I do remember the issues very clearly, and they are parallel to the issues in this case. The main question before the Supreme Court and then subsequently the District Court was whether my client, Sam Toll, qualified as a member of the press because the newspaper that he published, it was called The Storyteller. It was a very colorful Virginia City newspaper that he published only online. So the argument that the opposing side made in that case is identical in that, hey, he's not a newspaper under the statute. The plain meaning means, something that's printed on the press, not something that's published digitally. And the Supreme Court's analysis roundly rejected that. The constitutional issue raised by my friend on the other side was really ancillary to the main question in the case. The court used the Fourth Amendment and it's the evolving jurisprudence involving the Fourth Amendment over time to illustrate how statutory definitions and terms don't need to be updated every time there's a change in technology. That's why they were talking about thermal imaging and things like that. And I'm proud to say that that was an argument my co-counsel and I, John Marshall, made in our briefs and that the Supreme Court largely adopted in its order. So I think that's really a separate question than the one before the court. And along with the plain meaning rule is the duty to avoid interpreting a statute in a way that's overtly pedantic or a way that is so narrow that it produces an absurd result. And I think as a practical matter, there's no way, knowing Mr. Falcone's history, what he does, how many courts have considered him a press reporter, the Supreme Court's history of expressly recognizing him as a member of the press, that the implication that he's not because he doesn't publish a printed newspaper is an absurd result under the statute. And with that, we would submit, Your Honor.
Thank you, Mr. Busby. The writ's going to be granted for these reasons. Court's reviewed all of the case law. First, Nestor versus 8th Judicial District Court, 141 Nevada Advanced Opinion number 4, filed in January 30th of 2025. In that case, the Nevada Supreme Court referenced the plaintiff in this case as a press organization who had asked for media access and directed the lower court to conduct the legal analysis of whether or not that access should have been granted. Also, in Falcone versus 8th Judicial District Court, 543 P. 3rd, 1992, which is a 2024 case from February, there the court referenced the plaintiff here that he had filed a media request for camera access, and the Nevada Supreme Court reversed the lower court for not allowing media access in that case. The next case is our Nevada Judges versus the 8th Judicial District Court. That's number 88412, and that was filed September 12th of 2024. here, the Supreme Court noted that the plaintiff filed a media request in that case. The final case is Toll versus Wilson, 135 Nevada Advanced Opinion 58. In this particular case, the statute at issue was NRS 49.275. And when you read that statute with the statute at issue here, which is NRS 482.3672, they are almost identical in their language with respect to the issue in this case. And here we have someone who has an online, essentially court TV for the state of Nevada, who's asking for media protections with a press plate. In the Toll case, and I read it, it was about whether or not he had to reveal his source. And in that particular case, he was a blogger, which is much more narrow in scope than the plaintiff in this case, who's not just a blogger, but who also has statistics and some analysis and commentary and videos, essentially functioning as a court online television channel for members of the public. And in Toll, the Supreme Court said, when a court is interpreting a statute, they should resolve any doubt as to what is reasonable versus unreasonable. And in Toll, they said the blogger was entitled to media protections as a reporter. And here, the plaintiff is also similarly entitled to those same laws when it comes to a press plate or any other issues with respect to requesting media access. And the Supreme Court, time and time again, has referenced the petitioner here as a media organization who seeks camera access and media requests. And so this court is not legislating from the bench. The court is not being an activist. The court is simply following the law as set forth by the legislature and as interpreted by the Nevada Supreme Court. So for those reasons, the writ is granted. Mr. Busby, can you prepare findings of fact, conclusions of law consistent with the court's oral ruling, the pleadings and papers and file hearing, and the arguments of counsel?
We'd be glad to do so, Your Honor. Thank you.
Thank you. Have a great day.
Thank you, Your Honor. Have a great day.
Thank you. You too.